Yes.
That's a listed matter for admission. Item number 1.
But I'm appearing my file myself. But in this case, my lord, here SSC is a my lord, HUF, my lord. My lord, there was a my lord, on my lord 26th day of
Under
March
service.
2014, my lord.
You give the file, main file. Slowly.
My lord, sorry, my lord. My lord, on 26th of March 2014, it has
271 what?
yes, yes. But may I just only 5 minutes I'll take, my lord. But SSC is an HUF, my lord. There was a partition on 26th day of March 2014, my lord, whereby, my lord, it was mutually agreed that it will be this HUF will be dissolved and entire amount will be transferred to the individual members. So, my lord, during the assessment, my lord, 13, 14, 15, my lord, the SSC HUF, my lord, they have claimed a long-term capital loss of rupees 7 crores and not. Since, my lord, this is a share, my lord, it cannot be treated as a transfer, my lord. That's why, my lord, SSC was asked to explain the entire thing, my lord. If your lordship will kindly come to, my lord, the assessment order starts at page 9, my lord. If your lordship will kindly come to, my lord, page 11 for once, my lord. The SSC was issued a show cause notice on 23rd of December 2016, my lord, to explain, my lord. The year SSC had computed the total capital loss or gain on the sale of shares which were held in the investments and trading in its books of account as on 31st March 2013. And any further purchase of the shares during the financial year 13-14, the capital gain has been computed on the assets that was held by the HUF and it is acquired by the HUF as on its own. No gain or loss has been computed on the assets distributed by the members of the petition. Further, no capital gain or loss has been computed by the SSC on the assets transferred mentioned in the portion as in the HUF. In view of the fact that the assets transfers to its members upon the portion of HUF, no loss of shares has been computed as the said distribution has been done in the cash book under to the tune of the post provisions as per section 47 Act. Note, SSC has contended that no capital gain or loss has been computed by the SSC on the assets shares transferred to its members on partition of the HUF, but from the record, it is clear that the SSC has booked a gain or loss from the dissolution of HUF. No capital gain or loss can be computed on the portion of the HUF as the same is not treated as transfer. Therefore, during the penalty proceedings, the SSC was given an opportunity of being heard by issuing a so-called notice under section 24. The SSC made written submissions. The explanation of 271(1) was considered. Thereafter, a penalty was imposed. So, what he has done, he has book a capital loss, by transferring his shares. The shares was transferred to his own members. So it cannot be treated as transfer. So, that capital gain or loss cannot be done. So there was therefore, penalty proceeding was initiated. CIT appeal was also, confirmed, if your lordship will kindly sees, CIT's order starts at, page number 13. If your lordship will kindly come to paragraph 10 onwards, page number 35. Yes. I have considered the recent submissions of the appellant and the orders of the assessing officer. And the appellant, the HUF during the previous year 13-14 was in the business of financial services. It was underwent a partition on 26th of March 2014. 5 days before the end of the previous year, it filed ITR such and such after dissolution in the capacity of Sri Chandravan Desai HUF, the appellant itself. Upon transfer to the members as per the terms of agreement dated 26 March 2014 to the 4 members. The long-term capital assets were also partitions. The appellant claimed long-term capital loss of to the tune of 4 crores 20 lakhs 90,000, which included long-term capital loss of STT to the of rupees 7 crore 29 lakhs 59,117 on dissolutions of the HUF. Being partitions among 4 members, their shares were shown as long-term investments in the balance sheet, are capital assets, but their transfer to the members is not a transfer for the purpose of calculation of capital gain or loss as per section 45 or section 47 says any distribution of capital assets on a partition of HUF is not regarded as transfer. The appellant has argued that the section 148 was against a non-existent entity as HUF was dissolved, but this is not a correct. As when ITR was filed after dissolution of HUF, the names of the same appellant HUF then the notice should also be held valid more so when the assessment for the previous year in which the entity exists has to be computed in the same name under which the name of the ITR was filed. Further reliance is placed on the rationale the following cases were placed, my lord. Therefore, my lord, it was dismissed. My lord, regarding the ground number 4, the ground on which the penalty was initiated was ultimate ground on which the penalty was levied were different. The assessment order under 143 was passed on 30/12/2016, making an addition of rupees 7 crore 29 lakhs 59,117 on the ground of the resolution of long-term capital loss on resolution of HUF, and simultaneously penalty proceedings under section 271 1C were initiated, and in response to the show cause, the appellant responded on 5/12/2016 without raising any technical objection. In fact, during the penalty proceedings, the appellant, by the submission of 27th January 2016, claimed that he had no motive for concealment of income, for giving inaccurate particulars of income, which were not found satisfactory. The appellant did not prefer appeal against the quantum of assessment regarding the correct limb of the notice of penalty. The appellant has cited the various case laws of such and such, my lord. In case of Samson, these are the case laws, my lord, they have cited, my lord. I'm keeping those case laws, my lord. They were cited, my lord. And thereafter, my lord, the conclusion, hence the ground raised by the appellant cannot be entertained, therefore it is dismissed. Now, coming to the merits of the case, the argument by the paragraph 16 of the appellant is that the HUF had a loss which will serve no purpose as it won't be carried forward. Since the HUF was being partitioned, but the appellant not incorrectly adjudicated the long-term capital gain, which with the loss created by the internal transfer of assets, which is not transfer as per provision of capital gain, then it would have to pay the taxes for this assessment year in the ITR. The irrespective of the partition of HUF on gain made on listed shares, etc. during the year, the catch here lies that the no capital gain loss can be computed on the partition of HUF, as the same is not treated as transfer. And perhaps that is the reason why the appellant did not prefer further appeal. The appellant later on argued that it brought to the notice of the assessing officer the long-term capital loss of 7.29 crores was mistakenly claimed by the appellant in the ITR, and neither deliberate nor mechanism. However, the subsequent acceptance cannot be entertained. Reliance is placed on this is in the case of Prasanna Dugar, and therefore, Lord, the contention of the appellant is during the appeal cannot be considered to be a best treated as an thought, as the appellant had given reply to the counter the assessing officer's contentions during the penalty proceedings, and stating that the actions as a mistake, and and now is arguing in the conceding the merits. Thus, the entire plan for resolution was keeping in mind to avoid that was the contention, and thereafter, my lord, it was, my lord, the appeal was dismissed. Now, my lord, before the tribunal, my lord, tribunal has gone on a totally different footing. Tribunal says, my lord, the company has dissolved, so there is no entity, so you cannot do anything. But, my lord, there is a section 171, if your lordship will kindly, section 171(4), my lord, and 171. My lord, if your lordship will kindly see the tribunal's order, my lord, I'm placing, then I'm placing the sections, my lord. Your lordship's tribunal's order starts at, my lord, page number 41. If your lordship will kindly see.
171, is it?
Yes, section 171, yes. But if your lordship will kindly see section 171, subsection 4 and subsection 8. May I just... 171. Yes. Well, 171 starts in the assessment after the partition of Hindu undivided family, my lord. 171, a Hindu family here too is assessed an individual as an undivided family shall be deemed to, for the purpose of this act, continue the Hindu undivided family. I am skipping my lordship will kindly see in the section subsection 4, where a finding of a total or partial portion has been recorded by the assessing officer under this section, and the partitions took place during the previous year, the total income of the joint family in respect of the period up to the date of the partition shall be assessed as if no partition shall taken place, and each member of the group of the members shall, in addition to any tax for which he or it may be separately liable, and notwithstanding anything contained in subclause 2 of section 10, jointly and severally liable for tax of the income so assessed. Plus, this is subsection 4, and subsection 8, if your lordship will kindly see, the provisions of this section shall, insofar as may be applied to the in relation to the levy of and collections of any penalty, interest, fine, or other sum in respect of any period up to the date of the partitions, whether total or partial, of a Hindu undivided family, as they apply in relations to levy and collections of tax in respect of such period. Lord,
But was this argument placed before the tribunal?
Lord,
You have not referred to 171.
it was not referred. Lord, tribunal's order does not say so. Lord, tribunal's order starts at page number 41. My lord, the lordship will kindly see, my lord, page number, paragraph 4, page number 44 is the conclusions. We have heard the rival contentions and perused the material placed before us. Penalty levied under by the learned assessing officer and confirmed the CIT appeal act or challenge before us. The first legal ground raised by the SSC is that the order passed in the name of a non-existent person is void ab initio and bad in law. Placing reliance was done by PCIT versus Maruti Suzuki, and claimed that before us that the assessing officer was very much aware of that the HUF was resolved on 26 March 2014, and therefore any further proceedings could not have been carried out in the name of a non-existing entity. We observe the notice 274 of the Act has been issued on 30/12/2016, levying a charge against the SSC for having furnished inaccurate particulars of income, and thereafter framed the penalty order under on 30th June 2017 for a concealment of particulars of income. Accordingly, admittedly, both the show cause notice under section 274 of the Act as well as the penalty order was same in the name of an HUF only. The Honorable Appeals Court in the case of Maruti Suzuki has held supra that the notices and the consequent orders issued in the name of non-existent persons renders the entire proceedings and all the subsequent actions can be nullity in the eye of law. Similar view was also taken in the case of Honorable Patna High Court. In the case of Commissioner was Sachir Singh Bhim Singh Shah, that is there was where
The tribunal, their contention was
yes,
it was revenue neutral.
my lord,
It was revenue neutral.
yes,
That was their contention.
revenue knows
Neutral.
neutral, yes,
So where is the question of levy of penalty? There are a lot of decisions on that point.
my lord.
And 171 was never canvassed.
So this revenue neutral part which my lords have observed, well, that was a very important aspect. But I had handed over to Ms.
Yes,
Learned
yes.
Friend with a copy of the assessment order that is not annexed. If my lords are pleased to have a look at it. Even though the assessor had also filed an section 154 application. But before my lords examine this note, may I just indicate the mistake which the assessor had made. This was a case of a complete partition of the Hindu undivided family. So it is when the assets are distributed, under section 47, they are not treated as transfers. Now the mistake which was made was in the return, this particular distribution was treated as transfer and the computation was made. But the figure came to some 7 crores odd. But in course of the assessment, this mistake was realized that this under section 47, it is not even treated as a transfer. Therefore, but the assessee demonstrated that look, even otherwise, there is no tax because I have losses for this year, has also brought forward losses. Now, in that background, kindly see the assessment audit starts at there's a handwritten page numbering. Page 2 is where it starts. Kindly have a look at page 14. It's the computation page. Kindly see the page 15 first, that last page. he computes a gross total income from capital gain of 36 lakhs. Now, I'm going to kindly see the prior page, the last item, addition, disallowance of capital loss on dissolution of HUF. So this, after adding back 7 crore 29 lakhs, but the gain was only 36. Now, the assessee had a carried forward loss of 58 lakhs. Now, kindly take the first page, Murthy. This was written to the assessing officer under section 154. The kindly see paragraph 1. The total income has been assessed at 36 lakhs in the captioned order. However, the brought forward long-term capital loss of previous years amounting to 58 lakhs has not been considered, pursuant to which the total income would be nil. Hence, there would be not be any tax payable by your assessee. And the extract of the schedule note of the return was enclosed. My lords will find that note at page 19. Note page 19, note kindly see schedule CFL. It's in the middle note. There's a heading, and note kindly see Roman 9. Total of earlier year losses 58 lakhs 93,223. And note this is under the heading long-term capital loss. So no, this was the assessee's application that look, there's absolutely no tax liability.
An order was passed under 154.
No, the order was not passed. Now, but the assessee was not it was not required to, that they did not insist on payment. Now, this fact is noted by the tribunal at page 43, if my lords are pleased to see. But page 43, middle of the page, the last word on that sentence, further it is noticed that. Further, it is noticed that the assessee did not challenge the addition made in the assessment order as it was tax neutral. But the penalty proceedings were initiated, though the assessee made submission that assessee did not gain anything from claiming the long-term capital loss, and it was an inadvertent mistake. Now, because the form was, the HUF was dissolved, so there was going to be no assessment. But sometimes the loss is claimed. If it is allowed, I get benefit in the subsequent years. But here there was going to be no other assessment at all. This was the last year. So there was no advantage being gained. So therefore this submission was made. Commissioner appeals, this argument was made. He says, no, there was tax payable for the year. But he lost.
He says it's false.
Yes, kindly see at page 38. The finding which he gives in paragraph 16. Coming to the merits of the case, the argument by the appellant is that the HUF had a loss which will serve no purpose as it won't be carried forward since the HUF was being partitioned. But had the appellant not incorrectly adjusted the long-term capital gain with the loss created by internal transfer of assets, which is not transfer as provisions of capital gain, then it would have to pay taxes for this assessment here in the ITR, irrespective of partition of HUF, on gains made on listed shares, etc. during the year. But this is factually incorrect, because there was actually going to be no taxable income at all after adjusting the loss of 58 lakhs. So much the figure of 2 crores 57 has come by taking 7 crores as the income which is income. But the assessment itself shows that it was 36 lakhs. In the normal course, 7 crore would have been counted if it was a case of a continuing. There was going to be a subsequent assessment where the assessee could have got the advantage.
One more point I think you canvassed was
Lordship.
But
he initiated on the ground that it was a case of yes, kindly see the
234 notice.
Yes,
what was the allegation in that?
Kindly see the assessment order, which I handed up to my lords. Kindly have a look at the assessment order at page 15, my lords. It's the last paragraph after the computation.
Yes.
Penalty notice under section 271(1)(c). I'm sorry, my lord, I took my lords to there's an earlier portion, if I may just draw attention to that. But at page 14, I'm sorry, my lord, page 14, just above the table, the paragraph above the table. The last 3 lines. I'm satisfied that the assessee has furnished inaccurate particulars. And in the penalty order, he says concealment. at page 12 of my lord's brief. After setting out
Then
this,
so and so
Lord.
is deemed to represent the income in respect of which particulars have been concealed.
So he has shifted ground. This was a bona fide mistake. The SSC owned up to it, explained
That's
it.
why they didn't raise a demand.
Yes.
Though you accepted the assessment order, because it was revenue neutral and carry forward loss was there.
Not
then
there. It was not
nothing.
there.
Then what about limitation? That's how the tribunal goes on limitation.
The tribunal went on one of the arguments only, although noting the tax neutrality part. The tribunal says that the order has been passed in the name of the HUF, which is already dissolved.
For which he refers to
Section 171(4) I was looking at. It makes the members of the dissolved HUF jointly and severally liable. In my humble submission, it is implicit that if they are being made liable, the order should be passed on them, so that they can prefer an appeal. Because otherwise, an order under Section 171 is appealable, an assessment order is appealable. So when joint and several liabilities sought to be imposed, and
so technically they should have issued notices to the four
co-partners.
who was.
So
And moreover, this deed of partition was considered by the assessing officer.
Yes, but he's accepted.
143.3, he has completed the assessment.
He's accepted the partition.
It.
He's accepted the total partition.
So even if you bring 171, as pointed out, you should have issued notices to the
individually to them.
4 individuals who are part of who are co-partners in the HUF.
Even 171(8), which my learned friend is referred to, regarding penalty, unless they are show caused, they have to be show caused. They have to then file appeals again.
Now the penalty you are imposed on a dissolved entity,
HUF, yes,
which is no longer in existence. Please comes. This appeal by the revenue filed under Section 260 Capital of Income Tax Act 1961 within bracket the Act is directed against the order dated April 17, 2024, passed by the Income Tax Appellate Tribunal B Bench Calcutta within bracket Tribunal in ITA number 674/KOL/2023 for the assessment year 2014-15. The revenue has raised the following substantial questions of law for consideration. Page 5, question A and B alone. A, B, and C already. We have heard so. The assessing officer completed the assessment for the assessment year under consideration under Section 143 within bracket 3 by order dated 30/12/2016. While completing the assessment, an addition of rupees 7,29,59,117 was made on the ground disallowance of capital loss on dissolution of the HUF. In the assessment order, the assessing officer had stated that he is satisfied that the assessee has furnished inaccurate particulars of income by claiming the said amount as deduction, and hence penalty proceedings under Section 271 within bracket 1 within bracket small c of the Act is initiated. The assessee filed a petition and rectification petition under Section 154 of the Act dated 27/3/2017, in which it was pointed out that the total income has been assessed at rupees 36,11,706 by the assessing officer. However, the brought forward long-term capital loss of previous years amounting to rupees 58,93,223 has not been considered, pursuant to which total income would be nil. Therefore, the assessee stated that there would not be any tax payable by the assessee. The necessary documents were also annexed to the petition filed under Section 154. It appears that no formal orders have been passed by the assessing officer in the petition filed under Section 154 of the Act, but at the same time, no tax has been demanded from the assessee, which would go to show that the entire issue is revenue neutral. Penalty proceedings were initiated, as noted above, on the alleged ground that the assessee furnished inaccurate particulars of income by claiming the said amount as deduction. The assessee submitted their reply to the show cause notice. Full stop. In this regard, a show cause notice dated 23/11/2016 was issued, to which the assessee submitted their reply dated 5/12/2016. Contending as follows. Sir, page. The assessing officer, while passing the order under section 271 (1) C of the Act, dated 30/6/2017, held that the added amount is deemed to represent the income in respect of which particulars have been concealed. Thus, the reason for levying penalty is contrary to the reason for which show cause notice was issued prior to commencement of the penalty proceedings. This is a serious error which would result the order as a nullity. The assessee carried the matter on appeal under section appeal before the National Faceless Appeal Center (NFAC). Contended that that the order of penalty has been passed on a non-existent person, namely the HUF, which has been dissolved, and the properties have been partitioned to the erstwhile co-partners. Further, it was contended that order of penalty is levied alleging concealment, on the ground of concealing particulars of income, whereas penalty proceedings were initiated on the alleged ground of furnishing inaccurate particulars. Further, the assessee contended that the limitation for initiation of proceedings expired on 30th June 2017, and therefore the entire proceedings are ab initio void. The assessee also placed reliance on various decisions, namely the decision of the Honorable Supreme Court in CIT versus Maruti Suzuki Limited, India Limited, 416 ITR 613, wherein the Honorable Supreme Court held that the notice and/or the consequent order issued in the name of non-existent person renders the entire proceedings and all consequent actions to be at nullity in the eye of law. Reliance was also placed on the decision of the High Court of Patna in CIT versus Sanichar Shah Bhim Shah, page 17, sir. 27 ITR 307, wherein it was held that when the assessee HUF had been completely partitioned, which was acknowledged by the assessing officer in the assessment order passed for the relevant year, and after completion of the assessment, when the assessing officer issued notice under section 28 (1) C and levied penalty for concealment of income upon the HUF, which was non-existent at the material time, on appeal, the penalty was cancelled. Reliance was also placed on the decision of the High Court of Andhra Pradesh in the case of Mahan Kali, page 18, sir. Subbarao, Mahan Kali, Nageswar Rao versus CIT 31 ITR 867, wherein it was held that the members of the erstwhile HUF were not liable to be penalized under Section 28 of the Act. This was a 1921 Act. Act within bracket 1921 bracket close. When the HUF was partitioned before the issue of penalty notice under Section 28. The assessee also pleaded that when the entire entire issue was revenue neutral, the question of imposition of penalty would not arise. In this regard, reliance was placed on the decision of the High Court of Gujarat in the case of CIT versus Gujarat State Fertilizers and Chemicals Limited, 36 taxman.com 533, wherein on it was held that, where an exercise of addition / disallowance ultimately results in tax neutrality, no penalty is leviable under Section 271 within bracket C of the Act. The contentions which were raised by the assessee did not find favor with the appellate authority, and by order dated 9th of May 2023, the appeal was rejected. Challenging the same, the assessee was on appeal before the learned tribunal. Though assessee challenged the order both on technical grounds as well as on merits, the learned tribunal, after going through the facts of the case, thought fit to decide the technical aspect of the matter, namely the legal issue, namely as to whether the penalty can be imposed on the HUF, which is no longer in existence. After taking note of the facts as well as the decisions cited by the decisions relied on by the assessee, the learned tribunal came to the conclusion that the assessee HUF was dissolved on 26/3/2014, and the notices for carrying out the penalty proceedings as well as the penalty order has been issued in the name of a non-existent entity. This fact having not been controverted by the revenue, the learned tribunal applied the decision of the Honorable Supreme Court in Maruti Suzuki India Limited and held that the entire penalty proceedings are ab initio void. One more aspect which was noted by the learned tribunal is that the assessee did not challenge the addition made in the assessment order as it was tax neutral. Apart from that, the revenue also did not raise a demand on the assessee, more particularly on the assessee pursuant to the pursuant to the assessment order dated 30/12/2016, presumably on account of the fact that they were satisfied with the case pleaded by the assessee in the rectification petition filed under Section 154 of the Act dated 27/3/2017. Mr. Doriel Leonard, Senior Standing Counsel for the Appellant Revenue, placed reliance on Section 171 of the Act. This contention was not raised by the revenue before the tribunal, nor it was one of the grounds on which the appellate authority sustained the order of penalty. Nonetheless, we have considered the said submission made by the learned senior standing counsel. Full stop. The reference was made to subsection 4 and section 8 of section 171 to support the stand of the revenue. Even assuming, without admitting that that section 171 could be relied on by the revenue, it goes without saying that the individual members of the erstwhile HUF, which has been since dissolved and partitioned completely, were never put on notice by the assessing officer before initiating penalty proceedings. This goes to the root of the matter, as a person cannot be condemned without being heard. Therefore, the argument based on argument by relying upon section 171 does not take the case of the revenue any forward. One more aspect is that one more aspect which we have taken note of is that the partition of the HUF in completely was accepted by the assessing officer while completing the assessment under section 143 within bracket 3 of the act, and therefore the assessing it will be too late in the day for the revenue to now turn back and say that they will not recognize the partition of the HUF in full form. As already noted, the reason for which notice was issued for initiating penalty proceedings is different from the conclusion which was arrived at by the assessing officer while passing the penalty order dated 30/6/2017. This is also yet another incurable defect which would call for interference of the penalty order. At this juncture, we need to point out that the law is well settled that the penalty proceedings are separate and independent from the assessment proceedings. Even assuming an addition has been made in the assessment proceedings, that will not automatically warrant levy of penalty. The revenue, don't say, there is a mandate cast on the revenue to show with sufficient material that there is concealment of income by the assessee, and the assessee attempted to evade payment of tax. In the instant case, the assessee had assessee upon partition of the HUF in full form mistakenly treated the assets in the hands of the erstwhile co-partners to be a transfer. This was subsequently ascertained during the course of assessment proceedings, and the assessee put forth the case to be one of genuine mistake. If that be the case, if that be the case on facts, it is also one more ground not to levy any penalty on the assessee. Thus, we are of the view that the learned tribunal was right in allowing the assessee's appeal and setting aside the penalty order. For the above reasons, the appeal filed with the revenue is dismissed and the substantial questions of law are answered on the above terms against the revenue.
I'm great.
Great from
Item number 2. Well, it is a addition under section 68. Now, the assessing officer contention is that this is accumulation entry. But the CIT appeal categorically recorded that this is a sale proceed of the investment. Lordship, kindly come to the assessment order. Start from page 9. But I am reading from page 10, middle portion. But during the course of assessment proceeding, AR of the SSC submitted that the SSC company is a non-banking financial company and engaged in the business of providing loan and advances. SSC company filed return of income showing meager amount of rupees such and such from the above business. The SSC has shown income from the dividend of such and such and interest of such and such during the financial 9-10, whereas the financial at 10-11, the SSC has shown earning of the dividend of rupees 1 lakh and interest rupees such and such. Now, skipping some lines from the ledger, it is seen that is 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. 13 from the bottom. From the ledger, it is seen that the SSC company received an amount of rupees 2 crore odd and rupees 30 lakhs on various days from the company of Shikshakti Communication and Investment Private Limited and Carnation Trading Private Limited, respectively through RTGS. During the course of proceeding, the report was discussed and stated that the above companies from which the SSC company received the fund was shell companies and companies were having dummy directors and which was mainly used for the accommodation entry and managed and controlled by Anand Singhania and other person like Dinesh Dhandania, Pankaj such and such, such and such, such and such, well-known entry operator of Kolkata. She was also stated that the notice under section 131 was issued to the company managed by them, but some same could not be served due to non-existence of the company at the given address. The current address of was also downloaded through the MCA data, and the proper inspector inquiry was conducted, and it is also shown that above companies were not existing at that address. Further, it is known that the director of the companies were no means from the analysis of the data, the companies were filed meager income of their directors. They are non-filer and filed very small income or nil income from the database of the department. It was reported that the companies were interlinked and existing, namely on papers having no real existence and were used for providing accommodation entry in various form. At least 11 companies' bank account were found, and on examination of the bank statement of the companies, it is observed that these accounts have frequently been used for depositing unaccounted cash, which were layered through the several bank accounts as shell companies. But I am led by Mr. Dutt.
No, let him be.
In the case of SSC company, the above two companies, Shikshakti Communication and Investment Private Limited and Carnation Trading Limited, were transferred of the account. I am skipping this. Third paragraph, during the proceeding of the SSC company did not prove the existence of company nor provided any other details on which AO can rely on the existence of the company. Hence, the genuineness and creditworthiness are also in question. Further, the SSC company stated that the SSC company had taken loan from the caption parties and to repay the other loan and the purchase share of the other companies. The SSC company also stated that the amount received was investment in the group companies.
But what do you say about the remand report? CIT
That
appeal.
is CIT appeal remand report, and CIT will categorically observe that this has the sale of the investment, and on that basis the tribunal also passed order, and there is no abatement in the assessment order regarding the investment.
That is why the assessing officer became wiser on remand report being called for. And here, after verification, he said this amount of 2.65 is received from Shiv Shakti and Carnation. It was not in the nature of unsecured loan, but represents proceeds received on sale of investment. Assessee submitted copies of sale invoice, details of investment sold during year were brought forward from the earlier years with verifiable from financial statement. Purchases were valid PAN and CIN. Engaged in business of money lending, making investment.
Actually, more effort has been given by the CIT appeal and the tribunal, only by the CIT appeal on the issue of 148.
If there was one more zero, we could have considered. Please come. This appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket the act is directed against the order dated 18 January 2024 passed by the Income Tax Appellate Tribunal B-Bench Calcutta within bracket tribunal in ITA number 812/KL/2023 for the assessment 2011-12. The revenue has raised the following substantial questions of law for consideration. A, B. B and C not required. You have heard Hari Akhtar, Soman Bhattacharya, JP Kirtan, Pruthvish Junjunwala, everybody. The short issue which falls for consideration is whether the learned tribunal was right in affirming the order passed by the Commissioner of Income Tax Appeals 21 Kolkata dated C8 within bracket CITA dated 10/5/2023 by which the assessee's appeal was allowed and the addition made under section 68 of the act was deleted. The assessing officer made the addition by invoking section 68 of the act on the ground that the assessee failed to discharge his owners to establish the identity, creditworthiness and genuineness of the transaction in respect of money received through cash trail. The learned tribunal, the CIT within bracket A, while in the course of hearing of the appeal, called for a remand report from the assessing officer. And the and in the said remand report, the assessing officer has in no uncertain terms accepted that the receipt of the impugned sum was on account of sale proceeds of investments. The assessing officer verified the investments sold were shown in the balance sheet for the financial year 2010-11 of the assessee in schedule 4, numerical 4 of the balance sheet. And after considering these facts, it was stated that the assessee had sold shares held by way of investment during the year to Messrs. Shiv Shakti Communication and Investment Private Limited and Messrs. Carnation Trade Link Private Limited. And it is not a receipt of unsecured loan. This fact, apart from other factual details, were considered by the CITA and by an elaborate order dated 10/5/2023, the appeal filed by the assessee was allowed. The tribunal on its part re-examined the factual position, took note of the findings rendered by the CITA and concurred with the same. We also find that the tribunal has also examined the factual position and took note of the remand report remand report as called for by the CIT appeals, which confirms that The alleged sum is on account of sale of investment and not otherwise. Thus, we find that no question of law, much less substantial question of law, arises for consideration in such. Village 1690. No separate application. In the stay petition, is any prayer is there? No, we have condoned it. GA1. Yeah.
Great.
Yes.
But I'm led by Mr. Dutt.
Capital letters. Dismissed.
Number 3.
But I'm appearing for the Milord appellant. But the matter, Milord, when Milord the
Delay is condoned already.
yes, Milord.
2-0.
Milord, here Milord the tax effect Milord is huge, but I find Milord very little on a place of submission. Because Milord, here Milord the assessee Milord accrued income in a specific assessment year 2017-18 by now Milord the it is a Milord issue relating to the Milord electricity charges that went up to Milord Supreme Court. And Milord the Supreme Court Milord last annexure page 87. Page 87 is the Milord operating portion Supreme Court order passed Milord page 53 order start page 53. Your Lordship kindly come to the Milord page 53. Milord page 53. This is the bunch of appeals by special leave. The appellant have assailed the legality, tenability of the separate orders dated such and such passed in writ petition such and such which relate to the writ petition filed by Magnancy Ori India Limited and MP number such and such, WP number such and such preferred by Hindustan Copper Limited. Now, in the penalty order, paragraph page 87. Lordship kindly see. Thus analyze, we find that the both of the cases, the different products of the commercial palace have emerged. Hence, we are inclined to think that the principle of non-sequitur of society has been applied. The logical corollary tariff has to be levied as means for manufacturing unit. Therefore, the analysis made by the High Court is not correct, and accordingly, judgment rendered by is deserved to be set aside and we so direct. However, during the period, if any amount has been paid by the appellant to the revenue, thus same shall be adjusted towards future demand. Now, in this year 17-18, the Milord assessee received Milord.
But in this case, they refunded it.
Yes, Milord assessee
Probably they were so powerful to get back the money. This order normally we pass like this. Any tax demand is there, you need not refund, you may adjust it to the subsequent demands. Similarly, tariff also, you can adjust with the other running bills or future bills. Then what did the tribunal do? It just followed the Supreme Court.
Yes.
So 17, 18, 18, 19, 19, 20, they adjusted it.
But assessing officer contention is that the amount was received in particular year, that should be taxed in the particular.
It is ratably to be distributed. Where the demand for the period, because they would have been made, the assessee would have made periodical payment.
Payments had been made, Milord.
Periodically. It's not in one lump sum. This 123 crores was paid.
But if you Lordship CIT appeals order page 31 or 32, it will be clear. But during the appellate proceeding, bottom portion, it was claimed by the appellant that on giving effect to the decision of the Honorable Supreme Court, the excess electricity charges paid by the appellant earlier to the MP State Electricity Board amounting rupees such and such became recoverable by the appellant from such and such, and the information these regards were duly shown by the appellant in the annual report and the statement of the account. In this regard, appellant file online submission and the relevant portion of the same is produced. That assessment year 17-18, 49 crores and odd, assessment year 18-19, 45 crores and odd, assessment year 19-20, 27 crores and odd. The appellant has already paid the due income tax on the above amounts of the respective years. The annual accounts of the financial year such and such, assessment year 17-18, the income of rupees such and such had duly been shown in the note of 30C under the head of other income and other income. I will not page number such a copy of the above referred, such a further a copy of the explanatory note appearing on page number 88 of the annual report is also enclosed. And will the tribunal, page below 47.
This tariff was imposed for that is segregating the mining activity into different.
No, the contest was whether the electricity duty will be 8% on the basis of manufacturing unit or as a mine at the rate of 40%. That was the contest. No, the SSC had been paying at 40%. Supreme Court ruled that no, it has to be 8% according on the basis that it's a manufacturing unit. Then whatever had been paid, they said you adjust it against future demand. So the SSC, in whichever year not the it was adjusted, in that year it is the income was it was offered to tax because that much less was claimed. So that's what the tribunal has said.
Please come. This appeal filed by the Revenue under Section 260 Capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 3rd October 2023 passed by the Income Tax Appellate Tribunal A Bench Calcutta within bracket Tribunal in ITA number 491/KOL/2023 for the assessment year 2017-18. The Revenue has raised the following substantial questions of law for consideration. Page 4 and 5, A and B. We have heard Mr. So-and-so, so-and-so. The learned tribunal allowed the assessee's appeal and set aside the order passed by the Commission of Income Tax Appeals within bracket CITA -NFAC, Delhi dated 24/3/2023 arising out of the assessment order under section 143 within bracket 3 dated 26/12/2019. The assessee contended that the appellate authority erred in confirming the addition in relation to recoverable excess electricity charges on the basis of the decision of the Honorable Supreme Court in Civil Appeal number 2464 of 2016 in Manganese Ore India Limited and others versus State of MP and others dated 10th November 2016. The learned tribunal noted the facts and the decision of the Honorable Supreme Court, wherein the Honorable Supreme Court held that the assessee was being charged for the electricity at the rates meant for mining, but the assessee are liable to be charged at the rates applicable for manufacturing units. Consequently, the assessee was entitled to the refund/adjustment of the excess amount of electricity dues paid in the preceding 3 years, namely 2016, 17-18, 18-19, and 19-20. The assessing officer was of the view that the assessee ought to have declared the amount received from the Madhya Pradesh State Electricity Board as income for the assessment year 2017-18 and accordingly made additions, which was affirmed by the appellate authority. The learned tribunal took note of the decision of the Honorable Supreme Court, by which the assessee was entitled for the refund of the excess amount of rupees 123.15 crores. In terms of the directions issued by the Honorable Supreme Court, the assessee was to adjust the excess amount towards future demands. Full stop. On facts, the learned tribunal noted that the assessee had correctly adjusted the receivables, adjusted the amount receivable from the Madhya Pradesh State Electricity Board against the electricity charges payable by them for the assessment year 17-18, and the remaining unadjusted amount was subsequently adjusted during the assessment year 2018-19 and 2019-20. Therefore, the tribunal found that the assessee has not claimed the electricity expenses for all the 3 assessment years, which indirectly means that the income of the assessee has increased by the total amount receivable from the assessee receivable by the assessee from the Madhya Pradesh State Electricity Board. Therefore, the tribunal came to the conclusion that on facts, it will tantamount to double addition in the hands of the assessee because the same has already been offered to tax during the assessment year 2018-19 and 2019-20 in terms of the directions of the Honorable Supreme Court in its order dated November 10, 2016. Thus, the learned tribunal was right in taking note of the directions issued by the Honorable Supreme Court and granting relief to the assessee. We find no grounds, we find no question of law, much less substantial question of law arising for consideration in this appeal. Accordingly, the appeal fails and is dismissed. This assessee has got a registered office in Kolkata.
Yes, register office in government and
No, is it?
no, it is a government undertaking. I'm told this. It's a PSU. It's public sector undertaking.
Item number 4.
May I please, Your Lordship? Service has been effected. My lord, a very small issue is involved in this matter. Very small issue. 263 was invoked because the assessing officer has not made any inquiry in respect of particular transaction or purchase of property. My lord, can we come to the findings of the tribunal at page 41?
You can't expect him to write a judgment.
No, my lord, if my
He
lord,
had issued notices, there is something records to show. See, during the course of assessment proceeding, assessee was asked to explain the books of accounts and bills, vouchers. AR of the assessee company filed, produced relevant documents and details with written explanation which examined, verified with the books of account, ITR hard copies, and the audit of computation sheet of assessee claimed excessive deduction, chapter 6A, claimed 80 IE, which will be allowed to the extent of business income. So, assessee is ask your commissioners to dispose of appeal instead of invoking 263.
no, it's a PCIT, my lord. The appeal is disposed
PCIT.
of by the CIT. My lord, kindly come to the assessing officer's order, my lord. Page 11. There is nothing, my lord, in this order. What view? The tribunal has held that the assessing officer has taken a plausible view, which may be different. But here from this order, it doesn't transpire that
You
the
come to page 18,
18, my lord.
reply to the notice under one for
My lord.
263.
Yes, this is the reply, my lord.
You see what all
Ah,
they have
in
done.
this in this
The fellow
reply,
has
my
been
lord,
sitting tight 5, 6, 7 hearings. He has done, that's all. How much is the addition?
addition is not much, my lord.
No.
3 crore 52 lakhs, my lord. Regarding purchase of property, the assessee has shown as work in progress. In reply, the assessee has stated that he had purchased what the property, the agreement for sale was registered, but he has shown as a capital work in progress. Ma'am.
But he has paid the entire sale consideration. Agreement was registered.
Yes,
Will it not fall within 247?
my lord, here the difference. What is the problem, my lord? The consideration money, the amount of the valuing authority, both are different. So addition has to be made. On this aspect, the assessing officer has not done any inquiry. Under section 56, my lord, these amounts are added as income from other property, income from other sources. And this regard, my lord, I'm citing 2 judgments. Paragraph 8 and 9, my lord. Sir, please.
There's nothing there.
My lord, and there is another judgment, my lord, of Delhi High Court.
Of course, he can use it. What is all this judgment? First, tell us on facts.
My lord, in this judgment also, the questionnaires were sent to the assessee, but the court has held
Sir, the assessment file will contain everything, no?
my lord,
What is his ground?
my lord.
You see on what ground? He invokes this power under 263. On a perusal of the assessment order, page 28, second paragraph.
My lord.
AO has not carried proper verification / investigation with regard to source of investment. What more can he expect the assessee to show? He has borrowed from ICICI Bank. There is a registered document. Amount has been paid. He responded to the questionnaire, furnished details, bank statement.
My lord is not
And therefore, he says proper verification.
no, my lord, here is not about the purchase only, my lord. The issue is not that the purchase, whether he has, assessee has shown purchase or not, oh, that is not.
The deed of conveyance is yet to be executed. Who was not?
But the valuation is taken if in the case, if the agreement for sale is on different date and deed of conveyance is on the different date, the valuation amount has to be taken from the agreement for sale, not on the deed of conveyance. Under section 50C, my lord.
In this case, it suits you to argue like
No, no,
this.
my lord.
Another matter, it will hurt.
My lord, this is Delhi Court High Court judgment, my lord. In this case also the
Not,
purchaser failed, but the Honorable Court has observed that. What is the view of the assessing officer? What is his mind?
All
He
right,
has to
sir.
speak.
Henceforth, let him write a judgment. Every assessment
No,
will
no.
take
My lord,
2
there's
years.
something at a one line at least should have been written. Nothing on this aspect. There is
All right, let your officer say, though he has said in the assessment order, in the second and third paragraphs, so and so, I saw the assessment file, there is not a scrap of paper, he didn't issue any notices, this is absolute falsehood. He says proper verification / investigation. What is proper according to you may not be proper according to me, vice versa. Yes, sir, what do you like to say?
Let's see. No, this was a case where it was selected by the computer aided selection
Yes.
system, CAS. But kindly see, if my lords are pleased to have at page, the assessment order, but at page
11.
12.
12.
Starts at 11. I'm going to kindly see at the bottom, note not for assessee. The CAS points have been checked. Now, the reason for the checking of the CAS points was the commissioner had not set out at page 54 in my 24, if my lords are pleased to have the reply.
Page 24,
Page 24 minutes.
34.
24 minutes. 24. There's an extract. This extract is from the assessee's letter dated 15 September 2017. It has been explained as under large investment in property AIR as compared to total income. This was the CAS point.
Page number is not telling. Page?
It is page 27. It must be page 27, para 6. I think that is the copy that they may be having. 27, para 6.
para 27.
I'm sorry, page 27 is the correct.
27.
27.
27.
But the paragraph 6. I have carefully considered the facts of the case and gone through the submission of the assessee. On perusal of the assessment record, it is seen that the primary reason for scrutiny, that is purchase of property for 11.41 crores, had not been verified at all by the AO. The AO accepted the claim only on the basis of ledger copy and some bank entries, and even the conveyance deed is not placed on record. On the other hand, AR of the assessee has stated that in course of assessment proceeding, the assessing officer has directed assessee to explain the above investment. The same was explained by the assessee's authorized representative by its letter dated 15 September 2017, wherein in para 4 it has been explained as under. Large investment in property, AIR as compared to total income. No, this was the query, but that notice has not been annexed to the petition. If my lords are pleased to have.
It has been annexed. Notice has been annexed at page 263 notice.
No, the
140.
140, that is not.
My lords are pleased to have. Serial number 12, my lords are pleased to have. This is 30th August 2017, and serial number 12. Large investment in property, AIR, there's annual information return as compared to total income. So this was the precise query because it was a CAS point. And the assessee answers it. Assessee has entered into an agreement for purchase of building at so-and-so on 28th November 2014. Total consideration is 11.41 crore. Copy of ledger of capital work in progress is enclosed because it was not capitalized yet. The conveyance had not been executed, showing the payment at various dates. Assessee availed loan from ICICI Bank for such purchase of property. Copy of bank statement, various bank has been enclosed for payment made. So they furnished, they mentioned that it's a loan taken, furnish the bank statements.
Because in Maharashtra, I don't think so. They register it before the sub-register. The agreement is generally registered with the cooperative.
No.
Yes.
In West Bengal, The agreement for sale,
Maharashtra.
even Maharashtra, any agreement has to be registered before the registering authority.
It has been done before the joint register.
That
But
is the registrar.
Normally what happens is there is a cooperative. You register it with the cooperative and the cooperative in turn will submit its returns saying that as on date, who are all the owners of the property. That cooperative office will be situated within the complex, both in Delhi and in Maharashtra.
My lord, I am not aware of that. Maybe
But
that
in
is
West
for the
Bengal and
cooperative.
other states, you have to register. But he has been put in possession, entire sale consideration paid, agreement has been registered with the joint register Mumbai City, Roman 4. He has issued notices, he has verified.
The next page, kindly see at page 28, the new paragraph on perusal of the assessment order and record, it is seen that the AO has not.
Carried out proper.
No, here he's asked for it. Then he notes, not for the assessee that I've checked the cash points. Then he
Very smart officer.
No, they have annexed it here, my lord.
And in some other case, you produce these cash points. What are they? That's a checklist only for the department. We'll also see that.
No, these are copied here. No, these in the notice which 30th August. These are the cash points.
Oh, these are the cash.
These are the cash points. But he's putting me on notice that you have to explain all this.
14 items he has called for.
Yes, and the 12th is not large investment in property. He gets the information from the.
Vanga, please come. This appeal by the revenue filed under section 260 Cap of Income Tax Act 1961 within bracket the act is directed against order dated February 27, 2024 passed by the Income Tax Appellate Tribunal B Bench Kolkata within bracket Tribunal ITA 382/KOL/2021 for the assessment year 2015-16. The revenue has raised the following substantial questions of law for consideration. Page number 6 and 7, 1, 2, 3, Roman 1, Roman 2, Roman. You have heard Amit Sharma, etc., etc. The assessee was on appeal before the learned tribunal, challenging the order passed by the Principal Commissioner of Income Tax, -2, Kolkata within bracket PCIT, or you can put capital P, small r, full stop, CIT, Principal CIT. CIT dated 10th June 2020 under section 263 of the Act. For the PCIT to exercise jurisdiction under section 263 of the Act, he has to first examine the records of the proceedings under the Act. And should consider the order passed by the assessing officer and form an opinion that such an order is erroneous in so far as it is prejudicial to the interest of revenue. After forming such an opinion, show cause notice has to be issued to the assessee, and the assessee would be given an opportunity to explain. The PCIT would be empowered to conduct an inquiry as he deems fit and proper. After receiving the explanation of the assessee, it will be well open to the PCIT to set aside the assessment order passed by the assessing officer. He may also enhance the assessed income by modifying the order. And he may also set aside the order of the assessing officer and direct him to pass fresh orders. Honorable Supreme Court in Malabar Industrial Company Limited versus CIT 2243 ITR 83 within bracket AC held that the phrase prejudicial to the interest of revenue within inverted comma from prejudicial to revenue has to be read in conjunction with an erroneous order passed by the assessing officer, semicolon, every loss of revenue as a consequence of an order of the assessing officer cannot be treated as prejudicial to the interests of revenue. The learned tribunal took note of the legal position and examined as to whether the PCIT could have invoked this power under section 263 of the Act. At the time when notice was issued to the assessee, the PCIT observed that stated that the primary reason for scrutiny was purchase of a property for rupees 11.41 crores, which has not been verified at all by the assessing officer. The issue is whether this prima facie finding was justified. The learned senior standing counsel appearing for the revenue would strenuously contend that the assessment order is a non-speaking order, bereft of any particulars, which will clearly show that the assessing officer did not consider any of the aspects and the PCIT was justified in invoking its power under section 263 of the Act. We have perused the assessment order dated 10/11/2017, passed under section 143 within bracket 3 of the Act. During the course of assessment proceeding, the assessee was asked to explain books of accounts and bills and vouchers, and the assessee filed/produced the relevant documents and details with written explanation, which were examined by the assessing officer and verified with the books of accounts and the income tax returns and the audited accounts. Furthermore, during the course of assessment, the assessing officer assessee produced computation statement, etc., which was also considered, and thereafter the assessment was completed by order dated 10/11/2017. In the last paragraph of the order, there is a note which is not for assessee, inverted comma, which states, inverted comma, the CAS points have been checked, inverted comma, close. This note, which is not for the assessee, will show that there has been due application of mind by the assessing officer. The learned senior counsel appearing for the respondent assessee has produced a copy of the notice issued by the assessing officer under section 142 within bracket 1 of the Act dated 30/8/2017. In the said notice, as much as 14 queries have been raised, and one among the queries is query number 12 within inverted comma, large investment in property within bracket AIR bracket close as compared to total income. Thus, the issue relating to acquisition of the property was subject matter of consideration before the assessing officer. The assessee submitted their explanation to the same, contending that the assessee has entered into an agreement for purchase of building at Upper Worli, WORLI, Mumbai, from Srinivas Cotton Mills Limited on 28th November 2014, and the total sale consideration is rupees 11,41,07,130. Full stop. The copy of the ledger of the capital with WIP within bracket building account was enclosed, showing the payments were made on various dates. Further, the assessee stated that they availed loan from ICICI Bank for purchase of such property, and the copy of the bank statement of various banks have been enclosed to show the payments made to Srinivas Cotton Mills Limited. Further, the assessee submitted that the possession of the aforesaid property was not handed over by the seller to the assessee before 31/3/2015, and the amount paid by them is reflected in the balance sheet as at 31/3/2015 under the head within inverted comma capital work in progress. The relevant terms and conditions. Further, the assessee stated that the agreement for purchase was duly registered with the joint registrar, Mumbai City, Roman 4. Considering all these aspects, the assessing officer completed the assessment. Though the aforementioned points were placed by the assessee in response to the show cause notice issued under section 263 of the Act, the PCIT opined that the PCIT confirmed the proposal in the show cause notice, not on the ground which was proposed in the show cause notice, that the assessee did not do any verification, but on the ground that the assessing officer did not do any verification at all, but on the ground that the assessing officer has not carried proper verification styles investigation. As pointed out above, the factual position clearly shows that there has been due verification done by the assessing officer, and the assessing officer was also careful enough to note the cash CASS points, which were also verified by the assessing officer. Full stop. The learned senior standing counsel placed reliance on the decision of the decision in the case of Commission of Income Tax versus Anand Kumar Jain, 2015 57taxman.com 372 within bracket Allahabad, wherein the Honorable Court held that the assessing officer during scrutiny did not apply his mind to scrutinize the identity and capacity of lenders who furnished loans, and the matter was to be re-adjudicated. In the case on hand, the factual position has been set out in the preceding paragraphs, which will go to show that the assessing officer did cost verification with the aspect pointed out by the PCIT, that is with regard to the alleged large investment in property. Therefore, the decision in Anand Kumar Jain will not be of assistance to the case of the revenue. Reliance was also placed on the decision in the case of Principal Commission of Income Tax versus Ms. Sangeeta Jain, 2020-2024, 168taxman.com 276 within bracket Delhi. In the said case, the assessing officer, assessing officer accepted the assessee's claim that the land in question was sold by her was agricultural land without verifying records, without verifying records. And therefore, the principal commissioner rightly exercised his jurisdiction under section 263 of the Act. The factual position in the case on hand is entirely different, and we are satisfied that the assessing officer did cost verification with regard to the said investment by specifically calling for detail, which is amply established by the notice issued under section 142 within bracket 1 of the Act dated 30/8/2017. Thus, for all the above reasons, the order passed by the learned tribunal does not call for any interference. Accordingly, the appeal fails and dismissed. The substantial questions of law are answered against the revenue.
My lord, one more thing, my lord. I had forgotten to mention one thing. There is a delay of 164 days.
I think it has been condoned.
No, my lord. This is coming for the first time, my lord.
Oh, okay, sir. So condone the delay, sir. Thank you.
I'm grateful.
I thought it was condoned. Next. Condoned, yeah, investment.
I'm appearing for the plaintiff minority.
Item number 5,
Mr. Kaustav Chandra Dash is appearing in the matter.
Who's appearing?
Kaustav Chandra Dash. He has suffered a heart attack around 10 days back.
My
So I
goodness.
was praying for a
How old is he?
not very old. He's within 50s, I believe.
Oh, sure, you don't know him. You don't know.
No, my lord, I know that in this matter, Bhaumik is appearing. Sanjay.
With Mr. Kaustav Chandra Das.
Oh, acha, acha.
Who's appearing?
Mr. Sanjay Bhaumik.
Sanjay Bhomik and Mr. Kaustav Chandra Das. Both of them are appearing.
You are not ready. You don't know.
No, my lord.
This is an appeal under my lord Black Money Act. What? It will.
Then we'll have it after about 3 weeks.
Yes, my lord.
It is submitted that the learned advocate who is appearing in the matter is indisposed, and 3 weeks adjournment is sought for. List
you,
after list on so and so date. Next,
Item number 6.
Yes,
My lord, I am appearing in this matter. my
yes,
lord.
your lordship,
This-
I am for the respondent,
Your
My
lordship,
senior,
I am not the
Mr.
respondent SSC, your lordship.
connected through video call.
My lord, this matter was heard by your lordship. Justice Rai argued this matter. This is a classic case of section 68, my lord. The lordship will kindly have a look at the assessment order. My lord, here the SSC has raised, my lord, share face value of rupees 10 with a premium of rupees 6 crore
no,
50.
we heard the matter or the other division bench?
No, I think this.
Your lordship, partly you have heard, your lordship have heard this matter, partly.
This.
The department has already argued this matter, and now I was supposed to respond this matter, your lordship.
Okay, okay.
But here the
With some other constitution, your lordship, but your lordship were there.
No.
Your lordship with Justice Bhattacharya.
Ah, yes. Yeah, we heard the matter on 31st January.
yes.
For
Yes,
continuation it came.
Yes.
Yes.
Then we'll have to once again hear Mr. Doria,
Yes.
and then we'll hear Mr. Dubey.
Yes.
But probably we'll do it
And Friday, my lord, Friday top.
Friday. You are coming to court.
Oh, sorry. I'm sorry.
No, if you are coming, no
Well,
problem. We'll
I'm
open
sorry,
the
my
court.
lord. I'm sorry. Next week, Wednesday.
Let it come next week, sir.
Yes.
Your lordship, it would be, if it is Friday, that would be fine. Ideal for me. Next Friday, if it is okay for
Next
lordship.
Friday is holiday.
Oh,
Next Friday, after the Good
After that.
Friday. After that,
Friday week.
that is 28th.
20.
Sorry.
No,
25th. Yeah.
25th.
25th.
yes, your lordship.
25th.
List on 25th.
Much obliged.
My lord.
Much obliged.
My lord.
Yes, sir. You also take notes.
Much
Item
obliged.
number 7.
May I please, your lordship? My lord had directed me to intimate the
77 days.
No, my lord, that has been already condoned earlier. The matter was came up earlier when the lordship had directed me to intimate the assessee. I had served notice. My lord. This is my service of affidavit of service, and also intimated the learned advocate for the assessee who appears in the tribunal.
Somnath Ghosh.
Somnath Ghosh, my lord.
He is not.
No, not here. My lord. In this case, my lord, the approach of the tribunal is that since for the assessee's own case in another assessment year, certain
11,
order was
12, 14, 15.
11.
Decided similar.
My
You have filed appeal.
My lord, for those assessment years, the tax effect was low. The revenue cannot. So this approach should not have been taken by the tribunal. That is the crux of my case, my lord.
No.
Here the additions were made for violation of that TDS and large number of cash payments.
See,
My lord.
that is one way of looking at it.
My lord.
You look it from the angle of, take a look from angle of the assessee.
My lord.
So far as he is concerned, of course, each assessment year is independent, you will argue. But the issue, if it is a recurrent issue, and it has been decided early, and it has attained finality qua the assessee, why should not the tribunal follow that? Merely because it is low tax effect. See, if suppose the tribunal relies upon,
This is the paradox, man. I understood my
No,
what
you-
my
this-
is coming from my lord. I have understood my lord.
if the tribunal relies on assessee's case and decides another assessee's case, you can tell, no, sir, this order is not attained finality. We didn't file an appeal because, but this is inter-party, it is binding. That
But
is the issue.
I have the problem with
So
the
therefore,
department.
what you should have done is, you should have brought it under the exception, saying that a question of law exists, therefore we have to.
My lord, but that cannot be. If the case is below taxifate, it doesn't process the threshold. The revenue
Yes,
can.
sir, assessee's books of accounts were rejected.
That
and
is
the pro- and
audited
the,
books of us. Those were
profit was
audited.
estimated at 8%. Tribunal partly allowed it, reduced it to 6.75% on the contractual turnover. What is that?
My lord, my case is that the CIT appeal should not have rejected the books of accounts. He would disallowed. Here, my lord, what the assessee has done, he could not produce. He did not deducted the TDS. So, what is the purpose of these provisions, my lord?
For
TDS and
11, 12 to
for
14.
ensuring compliances. my lord.
No, this is reasonable orders. Why poor fellow you're.
It's not poor fellow, my lord. It's not a poor fellow. He had violated section 40A, 1A, 40A3. These sections have been enshrined to ensuring the compliances. And here what happened, once the books of accounts are rejected, so the assessee is allowed to take advantage of his own wrong.
First is non-deduction of TDS.
Yes, man.
Two
There are
laborers.
labor. No. Addition in account of expenses and assessment. And assessee has expressed its inability to explain expenditure and provide bills. The assessee has submitted this. And there was labor contract account addition of violating the non-payment of TDS. And another is cash payment made.
I have perused the submission of the author as assessment order. Agreed that there were exigencies for making payment in cash. Also, a fact, some of these payments could have been made in check. Could not produce books of accounts as lost. Because after 5 years, you are raking up the issue. Because some survey was conducted. You picked up some empty loose sheets here and there. And you are flogging him.
And here, my lord, the assessee did not produce books of accounts on the pretext that its part-time accountant had misplaced laptop. And for the assessing officer, my lord,
but
the assessee had filed audited balance sheets, my lord.
You should have said that, sir, this is a recurring issue. So therefore, it's a fit case where we have to file an appeal. And this fellow is a labor contractor. He's a road contractor, is it?
Well, that but he does business on large scale. And my lord, his case was open pursuant to survey.
Not search.
Not survey, my lord, not search. My lord, kindly come to page 14 and 15 of the assessment order, my lord. Paragraph 3, my lord. On being asked to produce the books of accounts of the firm, the managing partner of the firm Sri Subir Kumar Das and the learned authorized representative of the firm, Sri Dulal Roy, stated that the books of accounts of the firm for the assessment year 13-14 was maintained by the accountant Sri Manoj Ghosh in Tally software in his laptop, and the laptop of the same was contained in a pen drive. They further stated both the laptop and the pen drive of the accountant got stolen, due to which the firm could not produce the books of accounts.
No, Mr. Sharma will confirm it. Please come. This appeal by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 14 December 2023 passed by the Income Tax Appellate Tribunal C Bench Kolkata in ITA numbers 2514/KOL for the assessment year 13-14 as well as ITA number 1605/KOL to 2019 for the assessment year 2013 within bracket cross appeal. The revenue has raised the following substantial questions of law for consideration. Question number 1 and 2, sir. 3 and 4 not required. We have heard Mr. Amit Sharma, learned senior standing counsel for the appellant revenue. Though the notice has been served on the respondent assessee, as well as the learned advocate who appeared for the respondent assessee before the tribunal, none appears for the assessee. The short issue which falls for consideration is whether the learned tribunal was right in sustaining an addition at the rate of 6.75% as against the profit estimated by the CITA at 8%. It is not in dispute that the identical issue arose in the assessee's own case for the assessment year 2011-12 and 2014-15, and the tribunal sustained the addition at 6.75%. The tribunal had, in the said order, had given elaborate reasons as to how the estimate should be 6.75% on the contractual turnover of the assessee and how it will be just, fair, and reasonable. It is not in dispute that the said order passed by the tribunal for the assessment years 2011-12 and 2014-15 has attained finality, and therefore it will bind not only the assessee but as well as the department. Therefore, the tribunal cannot be faulted for having followed the said order for the assessment year under consideration, namely 2013-14. 2013-14. Though it may be the case of the revenue that the revenue did not prefer an appeal considering the tax effect, yet inter partes, namely between the assessee and the department, the findings rendered by the tribunal for the assessment for the two assessment years 2011-12 and 2014-15 would bind the department, since the facts and circumstances are identical and no distinguishing features have been pointed out by the revenue. Thus, we find no question of law, much less substantial question of law arising for consideration. We'll stop with this, sir. We'll stop. Someone, you're also appearing? No.
No. Next matter is
Seven appeals, yes.